to choose an appropriate data center to store personal data in Russia. Vadim has covered the legal aspect of storing personal data in Russia. So now you have a mere understanding that you need to place databases which contain the personal data of Russian citizens in Russia. And at this point, you will start to look for a data center suitable for the purpose. You are probably interested, in having a checklist in order to complete this kind of research. And by the end of my presentation, hopefully you'll have some. So, before moving forward to the factors that can prove that data center is suitable for storage of personal data, I'd like to make a few points. First of all, when you approach a data center in order to place your infrastructure, you will mainly be interested in two types of services, either colocation or cloud service. The approach to understanding which data center will be suitable depends on the type of service you are interested in. Secondly, your choice might also be affected by the type of personal data you process in your infrastructure. I won't stop on the issue in detail since Boris in the next presentation will cover some issues and the respective regulation. I will only highlight a few points which are important in view of my presentation. So first of all, we discuss here the situation about when data is being processed in information systems. And in Russia, we have a document, the ruling of Russian government, which established 4 levels of security of information systems. And the level of security depends on the type and the quantity of personal data which is being processed in an information system and the threats existing in the system. So the letter brings us to a natural conclusion that before you select a data center, you need to know what data you are about to process, and the level of security must correspond with the information system involving personal data. I can assure you that by the end of presentation of Boris, you will be able to assess the required level of security which your information system requires. And during my presentation, I just ask you to remember this point because it will affect very strongly your choice of a data center. So now we can assess the requirements which is for data center in order to make it suitable for purpose of storing of personal data in compliance with Russian legislation. For either type of service, as it was said before, whether it's cloud or colocation service, data center infrastructure must be based in Russia. That is common. And the rest can vary. So when you choose the colocation service, that means that you place a server equipment which belongs to you in a data center. And actually, there are very few liabilities with regard to personal data processing, which might be attributable to data center. In fact, there is no personal data storage by data center in that case. So the customer itself covers all the issues with regard to personal data processing, and a data center is only responsible for physical security of server rooms. So in case with colocation, you only be interested in the contractual provisions covering DC responsibilities to ensure physical security of the premises where you locate your server equipment. It would be very different with the cloud service, because when you order cloud service, you order capacity within data center infrastructure in order to be able to process personal data. And well, there are a few advantages of choosing that kind of service, because before the colocation services, I mean, in comparison to it, cloud service is more scalable, and you don't need to make capital investments in infrastructure. So the majority of customers are interested in cloud services which comply with the legislation on personal data. And in case you order cloud service, the infrastructure is operated by a data center, which means you allocate the responsibilities established by law between the customer and the data center. So yeah, during my presentation today, I focused on cloud services. I mean, what is the approach to choose the appropriate data center for cloud services in order to comply with personal data requirements. This is the slide which demonstrates the basic plan and approach on how to ensure compliance with the law on personal data. I mean, step by step, 8 stages. And as you can see from the comments below, some responsibilities can be attributable only to the customer, while the others are joint responsibilities involving either data center or a contractor. So at this point, you might be wondering why I mentioned the contractor while describing the data center suitability for personal data storage. And here is the answer to this point. In fact, in Russia, we don't have any legislative requirements for data centers, like precise factors that data center should comply with in order to be suitable for data center, for personal data storage. Some of you who already operate in Russia and have some understanding on how to comply with Russian legislation might want to argue that point. Indeed, we're used to face the situation in the position that in case data center provides you with cloud solutions suitable for personal data storage, then such data center should hold a license for technical security of confidential information issued by a Federal Service for Technical and Expert Control. And actually, we've made some research and came to conclusions that that's not according to the law. The issue is that infrastructure suitable for processing of personal data shall meet several requirements. And such requirements are based on assessment of information system, on technical design specification, which shall be drafted by the company holding the respective license, and then project plan. And the documents I mentioned and implementation of the whole project indeed might be performed only by a company who holds the respective license for technical security of confidential information issued by STAC. And still, there are not such requirements that data center should hold a license. So basically, we came to a conclusion that either data center or a customer can hire a contractor holding the license who will perform all types of technical works in order to make sure that your infrastructure is suitable for personal data storage. Once again, it is good If data center has a license for technical security of confidential information, however, you still can place your personal data in the infrastructure of data center who is not licensed by stack, provided that either you, as a customer, or data center engage a contractor holding the respective license in order to assess information system being used for personal data storage and confirm it meets all the requirements established by law. The only obstacle in that case and of this approach is time consuming. I mean, if data center holds a license, so such data center could provide you service right upon request, and in case you will need to hire a contractor, that could lead to the extent of time frame of project, and this might be not possible when you have tight deadlines. The next issue which I wanted to cover is the data process agreement. And according to the law, you must conclude the data process agreement with data center when storing personal data in data center infrastructure. That follows from Article 6 of the law on personal data. Such agreement must be put in writing and ensure confidentiality and security of personal data. And in addition, all data subjects shall not only be aware, but give their written consent to engage a data center in storing their personal data. Actually, I haven't seen any practice of the regulatory authority so far. Maybe Vadim will comment on this later, but at this point, I would recommend to do the following. To describe the C data center in consent form in general, not stating the name of data center. Otherwise, you will need to refresh consent forms every time you move your infrastructure from one data center to another. And actually, that could be difficult to implement in reality. And the second issue that you will state the full name of data center engaged in personal data processing in privacy notice you make available on your website. So the list of conditions to be agreed with data center when storing personal data in Russia, they also stipulated in Article 6 of the Federal Law on Personal Data. And you can see the list of conditions in presentation. I would just make a few comments on this. The DPA should contain the commitment of data center to comply with the rules of the law. And then such an agreement should contain also the list of actions, authorized actions with personal data for data center, and also the purpose of processing the data. Such agreement also should contain the liability of data center to protect the confidentiality and to ensure security of personal data, and also the precise list of requirements in compliance with Article 19, which might be both technical and organizational measures which data center should meet and your infrastructure and data center should meet. The best practice also to indicate the level of security of cloud solution you are being provided. I mean, that also will be covered in presentation of Boris, but I also wanted to point it out. And actually, if data center has some kind of standard solution with regard to personal data processing, they probably have standard clauses, that DPA to be agreed upon with the customer. Otherwise, you will need to engage your lawyers in order to negotiate DPA conditions. So here we go with the checklist for data center. Based on what has just been discussed, you may find this checklist and just go through whenever you want to consider whether data center is suitable for storage of personal data in Russia or not. So it's very important point that the initial step shall be taken by a customer. You always need to know what data you process within your information systems, and based on this knowledge, you choose the decision, either cloud or colocation service, and then make a choice of data center. Okay, so that's all I wanted to share with you. Thank you.